Dear students, I welcome you on behalf of Thakur Vidya Mandir High School and Junior College for the remote teaching learning process, where our motto is let learning be a joy and teaching a pleasure.
Let us move towards part 6 of chapter number 3, that is issue of shares, wherein today we are going to understand about allotment of shares and the statutory provisions and general principles relating to allotment of shares. Before moving to our next question, let us first understand as to what is allotment of shares. The term allotment of shares means distribution of shares among those applicants who have applied for the same by means of written application. It thus means allocating or giving certain number of shares to an applicant based on the application submitted by them. This power to allot shares lies with the board of directors. Thus, firstly, company issues prospectus and application form to the general public. Further, the applicants fill the form and submit it with the application money to the company's bankers. Nextly, the board of directors accept these applications in the board meeting by passing a resolution which is thereby called as allotment of shares. Every company issuing shares has to follow the provisions laid down in Companies Act 2013 regarding allotment of shares. These provisions, which are also called as conditions for allotment, are divided into two categories, that is, statutory provisions and general principles. Let us understand both these provisions in detail. Let us now move towards our first question for today, which is question number 7 in chapter 3, that is, explain the statutory provisions for allotment of shares. Statutory provisions are those provisions which are laid down in Companies Act 2013. The first one is registration of prospectus. Whenever a company issues shares, it issues a document called as prospectus, which is an invitation to the general public to subscribe or purchase the shares of a company. Now, a copy of the prospectus must be filed with the registrar of companies either on the date of its publication or before the date of its publication. Further, this prospectus needs to be signed by every proposed director. That is, a proposed director is one who is not an actual director, but his name is proposed to be as a director in the future. Or it must be signed by a director himself or by a duly or properly authorized advocate, that is, a lawyer who is given authority or power by the director to sign on their behalf. Thus, the first provision states that it is compulsory for a company to register a copy of prospectus with the registrar of companies before it actually begins the procedure relating to allotment of shares. Let us now move towards the second statutory provision, which is application money. Application money refers to that money which is paid by the applicant along with the application form while applying for the shares of the company. The Companies Act specifies that an applicant has to pay a minimum of 5% of nominal value of shares. Now, we need to understand as to what is nominal value. The original value of a share which is printed on the share certificate is called its nominal value, or it is even called as face value of shares. Further, this amount may also be specified by SEBI. According to SEBI, a public company needs to collect at least 25% of nominal amount of shares as application money. Lastly, The applicant needs to pay the application money to the company's bankers about which it is specified in the prospectus. Let us now move towards the third statutory provision, which is minimum subscription. The minimum amount of shares which must be purchased by the subscribers is called as minimum subscription. The prospectus of the company must clearly specify as to what is the minimum subscription amount. Further, the Companies Act states that this amount must be collected by the company within a period of 30 days from the issue of prospectus. In addition to this, SEBI has specified that this amount should be 90% of the total amount of shares issued. Let us understand further more about minimum subscription. Suppose if the company is unable to collect or raise the minimum subscription amount, then it is said that the issue is undersubscribed. That is, it is a case of undersubscription wherein the number of shares for which the general public has applied is less than the number of shares which are offered by the company for subscription. Lastly, if the minimum amount of subscription is not collected within a period of 30 days from the issue of prospectus, then the company must return the entire amount of application money to the applicants or subscribers within a period of 15 days from the closure of issue. Thus, in order to avoid such situations, companies usually appoint underwriters and enter into an underwriting agreement with them. These underwriters give an assurance or guarantee that in case the company is unable to raise the minimum subscription amount, then they would take up, that is, purchase the remaining or unsold shares, and thereby they help the company to fulfill the requirement of minimum subscription. However, the company needs to pay them in the form of commission, which is called as underwriting commission. The fourth statutory provision is relating to closing of subscription list. Subscription list basically refers to the list of subscribers, that is the persons who have subscribed towards the shares of the company. As per the guidelines of SEBI, the subscription list must be kept open by the company for at least 3 working days, that is minimum 3 working days, but not more than 10 working days. This is the time period during which the applicants can apply for the shares of the company. Thus, it can be said that the applicants can give application for the shares only when the subscription list is open. That is, the time period is given to them, which is minimum 3 working days, and it should not be more than 10 working days. The fifth statutory provision is relating to the basis of allotment. The company needs to decide that how it will be allotting shares, that is, on what basis the distribution of shares will be made. There are different categories of subscribers like institutional investors, non-institutional investors, retail investors, etc. Now, the allotment will be decided for each of this category of subscribers. That is, the company will take decision as to how to allot shares to each of this category of subscribers. Further, allotment will be done as per the minimum application size, which will be fixed by the company. The sixth statutory provision relating to allotment of shares is oversubscription. Oversubscription refers to a situation where the number of applications received for the shares is more than the number of shares that the company has actually offered for the purpose of sale. According to SEBI guidelines, a company cannot allot more than the number of shares that it has actually offered. For example, if the company has offered 10,000 shares, then it cannot allot, that is, it cannot distribute more than 10,000 shares. However, under some special cases, SEBI may give permission to give, that is, allot more than the offer that it has made, but in such a case, it should not be more than 10% of the net offer which is made. Next, it is permission to deal on stock exchange. Whenever a company makes a public issue, it is compulsory on the part of the company to list its shares on stock exchanges. For this, the company has to take permission of this stock exchange, and thus it has to apply for the same to one or more recognized stock exchanges so that it can list their shares with them. Further, the prospectus must mention the name of the stock exchange on which it will be listing its shares, and also that it has made an application for the same, seeking or taking the permission to list its shares with the concerned stock exchange. Let us now move towards the eighth and the last statutory provision relating to allotment of shares, that is, appointment of manager to issue and various other agencies. Company must appoint either one or more merchant bankers who will act as managers to public issue of shares. These merchant bankers look after all the activities relating to public issue of shares. Further, it also needs to appoint registrar to issue who keeps a complete record of shareholders on behalf of the company. It also needs to appoint collecting bankers who collect the allotment money on behalf of the company. Besides this, the company also appoints underwriters who give a guarantee that they will help the company in raising the minimum subscription amount. Further, even brokers are appointed who help the company to trade their shares or securities in the stock exchange, that is stock market. And lastly, even advertising agents are appointed who help in popularizing or giving publicity to the shares of the company in the stock market. So with this, we have completed the 8 statutory provisions relating to allotment of shares. Let us now move towards the general principles or general conditions relating to allotment of shares. Besides the statutory provisions specified in Companies Act 2013, a company also needs to follow the below mentioned rules. The first one is proper authority. In a company, the board of directors are the proper authority who can allot the shares, which means that the board of directors are given the power to allot the shares to the applicants. But sometimes the board may delegate, that is, give their authority to an allotment committee set up by them who looks after the procedure relating to allotment of shares. The second general principle is allotment must be against application only. A company can allot shares only when it receives a written application for shares from the applicant. Without written application, a company cannot allot shares. If it does so, it would be treated as an invalid allotment. The third general condition is reasonable time. A company needs to make allotment of shares within a reasonable time period. The Act specifies that the company needs to allot shares within a period of 60 days from receiving of application money. Further, the company can start with the allotment procedure from 5th day after receiving from the date of issue of prospectus. The next condition is absolute and unconditional allotment. Further, the allotment must be absolute and unconditional, that is, company should allot or distribute shares on the same terms and conditions as it had stated in the prospectus and application form. During allotment of shares, it cannot make any changes in the terms of allotment. Besides, it cannot add new conditions at the time of allotment. So basically, it has to allot the shares as it is actually specified in the prospectus and application form. It cannot go beyond the rules and the regulations which are stated in the prospectus and application form. The next general condition is communication. Once the process of allotment gets over, it becomes the responsibility of the company to communicate about the same to the applicant by means of sending letter of allotment, which is also called as allotment advice. The allotment letter gives complete details relating to the number of the shares that have been allotted to the applicant, the amount which she is supposed to pay as allotment money, the last date for payment of allotment money, etc. The sixth condition is allotment should not be in contravention, that is, violation of any other law. A company cannot allot shares by violating, that is, going against any other existing laws. It needs to follow even other laws besides Companies Act 2013. For example, the shares cannot be allotted to a minor, that is, a person who is below the age of 18 years. Thus, with this, we have also completed the general principles or conditions relating to allotment of shares. Besides statutory provisions, we also need to understand still two more concepts relating to allotment of shares, that is regular allotment and irregular allotment. What is regular allotment? If a company fulfills all the above mentioned provisions, that is the statutory and the general provisions, while allotting shares, then such an allotment is called as a regular allotment. The next is irregular allotment. If a company fails to fulfill even if a single provision, in that case such allotment of shares is called as an irregular allotment and it also becomes an invalid allotment. Thank you, dear children, for your patience listening.